Moving on to the second principle which we are discussing today, which is the precautionary principle, also known as the precautionary approach in certain cases. A brief background about the precautionary principle first. The origins of the precautionary principle can be traced to Swedish and German environmental law and policy at the national level. Subsequently, it was mentioned in the World Charter for Nature of 1982, the North Sea Conference of 1984, and at the regional European Community level in the Bergen Ministerial Declaration on Sustainable Development of 1990. In the year 1992, in the course of the Rio Declaration, the precautionary principle was specifically taken note of in Principle 15. I will now quote Principle 15 of the Rio Declaration. It states that in order to protect the environment, the precautionary approach shall be widely applied by states according to their capabilities. Where there are threats of serious or irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. Here we see a shift away from using the language of principle towards considering the concept of precautionary approach. This formulation of the precautionary approach does not have a normative character of a rule of law, and it is phrased in very general terms. What it does is to help identify whether a legally significant risk exists by addressing the role of scientific uncertainty. But it also fails to do certain things. For example, it does not state what the measure should be, how the risk should be controlled, and what level of risk is socially acceptable. The reason for adopting the concept of an approach rather than a precautionary principle was at the insistence of the United States, because it was felt that the use of an approach rather than a principle offers greater flexibility and is less potentially restrictive. However, the difference between an approach and a principle is quite significant, because there are higher uncertainty and costs where there is a risk of irreversible harm, and there is a significant level of uncertainty and potential cost, the harm is less irreversible. So we find two sets of trends. When you look at the European treaties and the European Community law, they use the language of a precautionary principle, but when you look at international environmental agreements, often the language used is that of a precautionary approach or a precautionary measure. We also find a strong version and a weak version of the precautionary principle or approach. In the strong version, the potentially risky activity is banned. The burden of proof is on the proponent of the activity to demonstrate that the activity is benign and that it poses no or acceptable risk. However, it is felt that the adoption of such a strong version of the precautionary principle may stifle innovation and creativity, hamper scientific and technological advancement, and result in regulatory paralysis. This is the view held by a foremost academician, Cass Sunstein. This strong version of the precautionary principle is not supported in international law, but it has been supported by the Supreme Court of India in cases such as the Vellore case. The weak version of the precautionary principle states quite the opposite. The potentially risky activity is not banned, the burden of proof requirements are quite different, and therefore they still allow the room for innovation and creativity, which is one of the main concerns of the strong version of the precautionary principle. Principle 15 of the Rio Declaration, which talks about precautionary approach, has been widely endorsed by states. For example, in Agenda 21, one of the other major outcomes of the Rio Conference of 1992, it has been applied or endorsed by a growing number of international organizations and treaty bodies as a matter of policy or in the form of legally binding treaty principles and subsidiary rules. However, the thresholds of harm are different in different international environmental agreements. For example, in the United Nations Framework Convention on Climate Change, there must be a risk of serious or irreversible harm before the precautionary measures can be adopted. The Principle 15 idea of precautionary approach has been used in the International Court of Justice. For example, in the Gabčíkovo-Nagymáros case, this idea was relied on by Hungary. It was referred to with approval by Judge Veeramantri in his dissenting opinion. However, there was no reference by the International Court of Justice decision, although it was willing to apply new norms of international environmental law. In the pulp mills case of 2006, the idea of a precautionary approach was referred to in the dissenting opinion of ad hoc Judge Vinuesa. Principle 15 has also been applied in the decisions of the World Trade Organization, by the International Tribunal on the Law of the Seas. However, whether or not it is customary international law has been discussed, for example, in the WTO asbestos case, where the European Community argued that it was a customary international law principle, but this was not accepted by the appellate body of the World Trade Organization. More recently, in the year 2011, the Seabed Disputes Chamber, while hearing the advisory opinion on responsibilities and obligations of states sponsoring persons and entities with respect to activities in the area, observed that the incorporation of the precautionary approach into a growing number of international treaties and other instruments, many of which reflect the formulation of Principle 15 of the Rio Declaration, has initiated a trend towards making the approach part of customary international law. The number of issues associated with the precautionary principle or the precautionary approach. That changing the role of scientific data in environmental cases is the first one. The other problem is that this approach or principle is not applied universally. There are uncertainties in the meaning, application and implications of this principle, and the concept of precaution means different things in different contexts in terms of identification of risk, how to respond to that risk, etc. Also, in terms of what do the states have to do when they apply the precautionary principle or the precautionary approach presents another problem. Are the states required to act? Are they empowered to act? And are they encouraged to be more cautious? Are some of the questions which are often left unanswered. As I mentioned previously, in the context of domestic environmental jurisprudence, the precautionary principle has been invoked in the Vellore case, and three fundamental elements were noted by the court. The first being that the principle requires the state to take environmental measures to anticipate, prevent and attack the causes of environmental degradation. Second, where there are threats of serious and irreversible damage, lack of scientific certainty should not be used as a reason for postponing measures to prevent environmental degradation. And third, in terms of burden of proof, the onus of proof is on the actor or the developer or the industrialist to demonstrate that the proposed action is environmentally benign. The idea of precaution has also been invoked in other Supreme Court decisions. Some of them include Andhra Pradesh Pollution Control Board versus M.V. Naidu, a 1999 decision where the principle was used to emphasize the need for scientific inputs before adjudicating complicated issues of environmental pollution. In the 2002 decision in T.N. Godavarman Thirumalpad versus Union of India and others, where the court referenced the principle of proportionality, which requires a balancing of priorities of development and environmental protection, and a 2006 decision in the T.N. Godavarman Thirumalpad versus Union of India and others case, where the principle was used to advocate general precautionary measures by the Supreme Court of India.